All right, we're going to pick up and talk about how judges are appointed, and this is part of the lecture that deals with the politics of selecting judges. Okay. So this is a picture of John Roberts when Sotomayor was appointed and sworn in, and this is her husband and her mother who was present at the swearing-in ceremony. And Sotomayor is the first Mexican-American appointed to the Supreme Court. All right, so the process of selecting judges, federal judges, is highly partisan and highly political. And this is where, if you're a C-SPAN watcher, or even if you're not and you watch CNN or MSNBC or Fox, when there is an opportunity for the President of the United States to select a Supreme Court justice, it's on the news. They get brought before the Senate Judiciary Committee for questioning. And so this is a picture of Samuel Alito, who is being photographed during his second day of questioning before the Senate Judiciary Committee. And so judges are put through this grueling process of being vetted, being researched, getting a background checks, and then they go before the Senate Judiciary Committee for questions. And people on both sides of the aisle will ask the judges a lot of questions about certain issues, trying to get at whether or not they're going to rule in certain ways. All right? So again, federal judges are appointed by the president, and any appointments by the president have to be confirmed by 2/3 of the Senate. So when it comes to doing the Supreme Court judges, it's very, infrequent. I showed you a previous slide where a president might get one shot at appointing a Supreme Court justice, but there are a lot of district courts. Remember, there are 3 levels of federal judiciary courts. And so you obviously have the Supreme Court, but there's all those appellate judges that have to be appointed, and then all of those district judges that have to be appointed. So the President of the United States cannot be expected to know who to appoint to all these district courts out there across the United States. So they leave that up to, or get help from the senators, and this is called Senatorial Courtesy. Okay? And generally it's a custom that when the President has people to nominate to the federal judiciary, oftentimes he'll defer to the judgment of the senator from the President's party from that state as the nominee. So for example, in the state of Texas, Obama is not going to know what judges are living in the state of Texas and their background and who he should appoint to the district courts where there's an opening in the state of Texas. And so he would rely on the senators from this state. However, there are no Democratic senators from the state of Texas. So he might have to reach really deep down into his network of friends in order to figure out who to nominate as a federal judge in the state of Texas. Conversely, both California senators are Democrats, and so he would probably extend that senatorial courtesy to those 2 senators and defer to their judgment about who to nominate. Okay. But you can see, as I put there on the right, that during the Reagan-Bush years, the partisan divisions eroded this tradition of senatorial courtesy. So Obama, for example, is not going to reach out to the senators in the state of Texas because they're not from his political party. Okay? And so it's not to be expected. Okay? But that's what senatorial courtesy is. All right? So district court judges are often suggested by the senator from the president's party who represents that state where the vacancy has occurred. Okay? If neither senator, as in the case of Texas, is from the president's party, the governor or members of the state's House delegation might make suggestions. Okay? And then after that, they're confirmed by the Senate. The Senate Judiciary Committee does their work. Then they're confirmed by a majority vote of the full Senate. Okay? And then they get appointed to the bench. And these nominations tend to be intensely political or partisan, and presidents attempt to choose justices who share their own political philosophy. So the judiciary may give the impression of being completely apolitical, but jurists are in reality political officials who exercise the authority of a separate but equally powerful branch of government. So most judges are influenced by and base their decisions on personal, ideological, and partisan views. And so we should not think that judges don't. Okay. Oftentimes, the Senate Judiciary Committee want to know how they think the justices are going to vote, and this is called a litmus test. Okay. And a litmus test is just trying to figure out what a person's stand is on a particular key issue and whether or not they're going to be able to carry out their duties with an impartial point of view. So in political terms, a person's stand on a key issue that determines whether he or she will be appointed to public office is a litmus test, all right? And most justices, when they're being grilled by the judiciary, refuse to answer questions of this type of nature because they argue this is a hypothetical. I will make decisions based upon the rule of law. This is a picture of Robert Burke, who did not refuse to answer questions about how they would reveal or how they would decide a case. All right. So Bork was nominated by President Reagan in 1987, and afterwards there was a huge embroiled debate about his ability to serve on the Supreme Court. There were lots of oppositions from civil and women's rights groups when they heard about some of Bork's desire to roll back civil rights decisions during previous administrations. And remember, Reagan is a Republican. You had Senator Edward Kennedy give a speech opposing Bork's nomination, and Kennedy declared that Robert Bork's America is a land in which women would be forced into back alley abortions, blacks would sit at segregated lunch counters, rogue police would break down citizens' doors in midnight raids, school children could not be taught about evolution, writers and artists could be censored at the whim of government. And so Edward Kennedy, a Democrat, is launching this condemnation against Robert Bork, and it really brought on a big fight between conservatives and liberals in Congress about Bork's viewpoint. Okay. They painted Bork as an extremist. To pro-choice abortion rights groups, Bork's originalist views and his belief that the Constitution did not contain a general right to privacy was a clear signal that he would try to reverse Roe v. Wade. And so this became the litmus test. How would potential jurists rule on certain cases? So when they're before the Judiciary Committee, senators are going to try to see how would you rule in a civil rights case? How would you rule in an abortion case? How would you rule in this particular economic case? And any one of these questions could be seen as a litmus test to determine what their stand is on a key issue, to see if they're going to be supported by the rest of the Senate Judiciary Committee. And now when you hear about judicial nominees going before the U.S. Judiciary Committee, you might see Robert Bork's name be turned into a verb, that is to be borked. Okay? And the idea of to be borked is defined as an attempt to destroy a judicial nominee through an attack on his character, background, and philosophy. So this gentleman has now had his name turned into a verb. Okay, and so for example, when Clarence Thomas was being nominated to the Supreme Court, one of the members of the National Organization for Women wanted to defeat his nomination, and she said, "We're going to bork him." Okay, and so if you're trying to get rid of a nominee, it might be that you're trying to bork that person. All right. Let's talk about the confirmation of Clarence Thomas. This is Clarence Thomas when he was up for nomination, and this is Anita Hill, who was at the time a University of Oklahoma law professor, and she claimed that Thomas had sexually harassed her when they worked together at a government agency. Thomas denied the charges, and this brought out a lot of individuals for the National Organization of Women and other civil rights groups who really wanted to see Thomas not be appointed to the Supreme Court. But we know that he did, and so that effort failed. But you see this every time a particular judge is brought before the Supreme Court, brought before the Senate Judiciary Committee to answer questions about their past rulings and how they might rule in the future. So from the Bork incident as well as the Clarence Thomas incident, most judges now refuse to answer questions about hypothetical situations on how they might view or how they might rule in the future. All right, well, how do you confirm, and then how do you prevent someone from being confirmed? All right, so many times you have an effort to filibuster court nominees. Remember, the Constitution requires only a majority of the Senate to advise and consent to a presidential nominee. That means 60 votes are required, okay? So if you're wanting to block a nomination, you might filibuster. But unless you have more than 40 votes, you can't filibuster because 60 votes will end a filibuster. And so Democrats, before they lost this 60-vote majority, had used the filibuster to their advantage in Senate confirmations against certain court nominees. But in order to have a successful filibuster, you have to have more than 40 votes. Otherwise, 60 votes can end the filibuster. All right, let's talk a little bit about diversity in the judiciary. And one of the changes has been the expansion of women and minorities. And again, these are the three women who are currently on the U.S. Supreme Court: Sotomayor, Ginsburg, and Kagan. This is the only African American on the Supreme Court, Clarence Thomas. Of course, he has changed from how he looked back then, obviously 20-something odd years later. Okay. When we look at judicial nominations by gender over time, this is obviously to the entire federal judiciary, not the Supreme Court. You can see Johnson approved very few. Nixon and Ford didn't nominate any. Carter nominated quite a few. Reagan, Bush, Clinton, and then Bush again. Okay, I don't have Obama's figures there. And then by race and ethnicity, you can see the breakdown here. Whites still dominate the federal judiciary. It is changing over time, but you can see how underrepresented minorities are on the federal judiciary. Okay. Here's another way to look at who the federal judges are in terms of the federal judiciaries in 2009. Each one of these individuals represents 10 federal judges. So there are 884 white men and 193 white women. And you can see the breakdown of African American men and women and Hispanic men and women. So again, relative to the population at large, these groups are underrepresented in the federal judiciary. Okay. When it comes to the different courts by administration, again, this is a different way to look at the graph we just showed you. And you can see as we moved through time, you had much more minorities being nominated or appointed to the bench, but still you have a big advantage for Caucasians, whether male or female, in the federal judiciary. All right, just very briefly, a profile of the first woman to serve on the Supreme Court. This is Sandra Day OConnor. She was went to Stanford Law School, and she had lived in Arizona, but she was appointed by Ronald Reagan in 1981. And of course, Ronald Reagan is a conservative, and so he was hoping to have a lot of conservative decisions brought through by Sandra Day OConnor, but she has been instrumental in preserving the constitutional right to an abortion. So even though she's appointed by a Republican, she has been much more liberal on the issues when it comes to women's issues and issues of gender and the issue of abortion. All right, let's talk a little bit about the politics of the court. Okay. On the one hand, judges serve in a legal institution and make their decisions in a legal context. The facts of the case are the relevant circumstances of a legal dispute or offense, and they're determined by the trial courts. The Supreme Court and the appellate courts must respond to the facts of a dispute, relating them to some legal provision. The laws of a case are constitutional provisions, legislative statutes, or other judicial precedents that might apply to a particular dispute. So the Supreme Court's justices must base their decisions on an interpretation of the relevant laws. However, it would be naive to believe that politics don't matter. The court can exercise powers of judicial discretion in interpreting the laws, which is influenced by political factors. Public opinion is one of those outside influences, although the courts give it less importance than other officials. But interest groups can exert pressure on the court just like they can exert pressure on candidates through what are called amicus curiae, or friend of the court's briefs or lawsuits. So interest groups, particularly in the abortion case, can file an amicus curiae brief to an existing court case before the Supreme Court. Both the President and Congress have direct and indirect means of influencing the Supreme Court's decision. Congress can change the court size if it wanted. The executive branch plays a vital role in influencing the political and ideological membership of the court, as we just saw, how they appoint judges and how long those appointments are on the bench. And then the personal views of the individual justices have a strong influence on the position that they take on issues and cases. And many scholars contend that the justices' personal beliefs are the most significant influence in their legal opinions. And so philosophy of the judges matter, the partisanship, that is who appointed them, matters, and then they often classified as whether or not there's a lot of judicial activism or judicial restraint. Okay, and I'll talk about that here in a moment, but I just want to show you about public confidence in the different institutions in America. And you can see how Congress has the lowest level of the institutions of the branch of government in terms of confidence. Okay, the presidency, and then you see the Supreme Court. So of the three branches of government, the public has a lot of confidence in the Supreme Court, okay, because they see it as mostly unbiased relative to the presidency or Congress. However, even though these are legal questions at play, the philosophy of a particular individual on the court is going to matter, as does generally who appoints them, because presidents who are conservative want to appoint conservative judges, and presidents who are more liberal want to appoint more liberal judges. So politics matter. So let's define what we mean by judicial activism and judicial restraint. And this leads to the question of, should the court be more activist or should it show constraint? So since the Supreme Court's decisions inevitably reflect the political philosophy of its justices, they constitute a small political elite that wield a lot of significant power, especially since they have this power of judicial review. And some judges who are more activists are more likely to exercise judicial review than those who have more restraint. So judicial activism is the idea that the court should take an active role in using its powers to check the actions of Congress, legislatures, and the executive branch and its agencies. So I'll repeat that one more time. Judicial activism is the idea that the court should take an active role in using its powers to check the actions of congressional members, legislatures, that is states' legislature as well, and the executive branch and all the executive agencies. So supporters of an activist court claim that judicial activism is both necessary and proper. And a dominant view of judicial activism holds that the Supreme Court is obligated to promote social justice by vigorously protecting and expanding the rights of individuals. And many would argue that without judicial activism, the civil rights movement, for example, would never have come into play. Okay. Critics of an activist court point out that it has adopted the legislative role in enforcing broad social policies. So they point to a doctrine of judicial restraint. And judicial restraint means that the judiciary should respect precedent and defer to the judgment of the legislatures. That is, the Supreme Court should defer to the decisions made by elected representatives of the people in the legislative and executive branch. So those people who are critics of judicial activism argue that judges should use restraint and leave legislative matters to those in the legislative branch, and don't want to see judges making policy. They want legislators to make policy because those are the individuals who are elected, and federal judges are not elected. This dispute over judicial activism and judicial restraint is a dispute between majority rule and minority rights, reflecting competing values which cannot be resolved by an appeal to dogma or a fact. Okay? And so this argument between judicial activism and judicial restraint will play on for a very long time. What I'm about to say is a pretty broad generalization, and so generally speaking, Democrats tend to argue for more judicial activism and Republicans tend to vote for more judicial restraint. However, each one of those parties will use judicial activism when it's in their best interest to do so. Okay? All right. This concludes the lecture on the federal judiciary. Be sure to review the reading questions and the key terms posted. And the topics for next week is going to be the Texas judiciary.